Hello, everyone, and welcome. Today, we're diving into the essential procedural aspects of the Indian criminal justice system. We'll explore the Criminal Rules of Practice 2019, understand the summons trial procedure, and discuss the test identification parade, covering their definitions, purposes, and legal implications. First up, let's understand the Criminal Rules of Practice 2019. These are state-specific procedural guidelines, like those in Tamil Nadu, that supplement the broader Bharatiya Nagarik Suraksha Sanhita, or BNSS. Their main purpose is to ensure the smooth functioning of criminal courts and to streamline crucial processes like arrest documentation, evidence recording, first information report handling, and trial records management. By the end, you'll better understand how these rules guide courtroom conduct, documentation, and even procedures for things like legal aid, child witnesses, and managing court records. These rules of practice cover a wide range of essential areas. For instance, they detail how first information reports and occurrence reports should be properly received and forwarded, including their format and timelines. They also outline precise procedures for arrest and custody, ensuring safeguards like mandatory medical examinations and the rights of the accused. You'll find guidance on recording confessions, dying declarations, victim and witness statements, and even the rules for conducting test identification parades. The rules also address the bail application process, including verifying sureties, and how final police reports and complaints from agencies like CBI are submitted and scrutinized by the court. Courtroom practices are also covered, from advocate appearances to the execution of summons and warrants and even committal proceedings. There are specific guidelines for examining witnesses, including how to handle child witnesses and video conferencing evidence. And importantly, the rules establish robust systems for judicial record keeping, outlining the maintenance and preservation of various registers. Finally, they mandate judicial inquiries into custodial deaths and the provision of legal aid counsel, while also defining the supervision and inspection roles for judges and magistrates. Now, let's move to the summons trial. What exactly is a summons case? Well, simply put, it's any case that's not a warrant case. Warrant cases involve serious offenses punishable with death, life imprisonment, or more than 2 years in prison. So, summons cases are typically for less severe offenses, punishable with up to 2 years. They usually begin in court either through a police report after a first information report is registered, or from a direct complaint filed with a magistrate. These trials are governed by specific sections of the Bharatiya Nagarik Suraksha Sanhita, and are conducted before a magistrate. The procedure for a summons trial often starts when the accused appears in court. Unlike more formal trials, no lengthy charges are framed. Instead, the essence of the accusation is simply stated to them. They are then asked if they pled guilty. If they do, the magistrate can convict them right there based on their plea. For very minor or petty cases, the accused might not even need to appear in person. They can simply admit guilt and pay the fine by sending a letter through post. However, if the accused does not plead guilty and wishes to present a defense, the trial then proceeds to the next stage. When the accused doesn't plead guilty, the trial moves to the evidence stage. Here, both the prosecution and the defense present their witnesses, and their statements become evidence for the court to evaluate. Based on this appreciation of evidence, the magistrate will either acquit the accused if they are found not guilty of the offense or convict them if the offense is proven. There are also special conditions for acquittal. For instance, if the complainant fails to appear on a fixed date, the court now gives them a 30-day grace period under the new BNSS. If they still don't show up, or if the complainant dies, the accused is acquitted. Also, the complainant can withdraw their complaint at any stage before a final order, which also leads to acquittal. Magistrates also have the power to stop proceedings in certain summons cases, specifically those initiated based on a police report, not a direct complaint. This is typically done if the magistrate believes the police report or the allegations are fictitious or baseless. If proceedings are stopped after the evidence of principal witnesses has been recorded, the accused will be acquitted. If stopped before that, they will be discharged. It's important to note the difference. Discharge means the charges are dropped and the trial does not proceed, while acquittal means the trial concluded with a finding of not guilty. Lastly, a magistrate can convert a summons case into a warrant case if the offense carries more than 6 months imprisonment and it's deemed necessary in the interest of justice that the case be tried following the procedure for a warrant trial. Moving on to the test identification parade, or TIP. This is a process where a witness tries to ascertain the identity of an accused person by testing their memory. Its main goal isn't to be a standalone proof of guilt, but rather to verify the trustworthiness of the witness's initial statement to the police and to see if the description provided matches the person they identify. A tip is not a substantive piece of evidence on its own. Instead, it's a corroborative tool, meaning it supports or confirms other evidence. It helps link the accused to the crime and tests the witness's ability to identify someone they might have only seen briefly. Legally, tips are admissible under Section 9 of the Evidence Act, and Section 54A of the CRPC, now part of the BNSS, specifically empowers courts to direct an arrested person to participate in one at the investigating officer's request. So, who conducts a tip? Importantly, tips are generally conducted by magistrates or any independent person not connected with the offense, never a police officer, as statements made to police while in custody are generally inadmissible as corroborative evidence. For maximum effectiveness, a tip should be conducted as soon as possible after arrest, ideally while the accused is still in custody, to preserve witness memory and prevent tampering. While delay itself may not reject evidence, reasons for delay must be provided. The procedure involves the accused standing in a lineup with 5 to 10 independent dummy persons who have no affiliation with the offense. The witness then identifies the accused from this lineup. Strict precautions are vital for fairness. The accused should not be shown to the witness or their photograph published prior to the tip. Dummy persons should be similar in features to the accused, and if the accused has distinguishing marks, efforts should be made to conceal them or have dummies with similar marks. If there are multiple witnesses, they should be called simultaneously but not allowed to mingle or discuss with each other. Any objections raised by the accused during the parade must be recorded. If an accused refuses to appear for a tip when ordered by a magistrate, an adverse presumption can be drawn against them. Child witnesses can also participate, and general guidelines remain, with the environment made suitable for them. Remember, a TIP's evidentiary value relies on the witness also identifying the accused in court during the actual trial. Otherwise, the tip itself holds no value, as identification in court is considered more substantive. In conclusion, the Criminal Rules of Practice, 2019, together with the BNSS, create a robust and detailed framework for criminal justice, ensuring clarity from the initial FIR to final record keeping. The summons trial offers an efficient process for less severe offenses, with built-in safeguards for fairness and adaptability. And the test identification parade serves as a vital corroborative tool for verifying witness identification, emphasizing the need for strict procedural adherence and prompt execution. Ultimately, the proper application of these rules and procedures is essential for ensuring fairness, reliability, and due process within our criminal justice system, strengthening the entire chain of evidence. Thank you for joining us today.